My name is Joseph McDaniel, and I'm an Arizona bankruptcy attorney. And since the 2005 amendments, I'm also a debt relief agency. I help people and businesses file bankruptcies. Today's topic is what happens in a first meeting of creditors in a consumer Chapter 7 bankruptcy in the District of Arizona Bankruptcy Court. The first meeting of creditors may be the only hearing in a consumer Chapter 7 bankruptcy case. It's mandated in the Bankruptcy Code at 11 U.S.C. Section 341, and because of that, it's referred to among bankruptcy lawyers as a 341 hearing. The 341 meeting is an examination of the debtor under oath and under penalty of perjury. A few years ago, the questions at a 341 meeting were posed by the debtor's attorney, but the practice now is that they are posed by the Bankruptcy Trustee, who is a fiduciary appointed at random from the panel of trustees in the district. So expect your bankruptcy lawyer to sit like a bump on a log during the hearing, because that's his or her correct role under the current system. Normally, in Phoenix, the hearing is held at the Bankruptcy Court building, and the proceedings are recorded with electronic equipment rather than with a court reporter. Bear in mind that you can't say or nod, because there's a recording. Because the meeting is held at that court building, the debtor coming in the front door must pass through a metal detector. Don't bring a pocket knife or any other weapon-like object, because it will take extra time to take it back to your car and talk to the officers about storing it, if that's your option, and that will make you late for the first meeting. Being late for your first meeting is bad. It makes the trustee unhappy, and when the trustee is unhappy, everybody is unhappy. The trustee normally needs to get through about 5 debtors every half hour. So the entire process is pretty quick unless the trustee has an unusual number of questions about a particular case. If he does, he may shorten the questions that he or she will ask and instead have the trustee's lawyer schedule a Rule 2004 examination of the debtor, which can be a multi-hour examination and is normally held at his attorney's office. But on average, a first meeting of creditors, the examination lasts about 5 minutes. The trustee sometimes takes roll call first and sometimes gives the oath to all the debtors at one time. Others give the oath to tell the truth, the whole truth, and nothing but the truth to the debtors individually. Some of the trustees also point out that there's a zero-tolerance policy for debtors who fail to list substantial assets and explain that the penalties for bankruptcy fraud may include 5 years in prison. If they weren't anxious before that, most consumer debtors who are unrepresented and unprepared for the hearing are pretty darned anxious thereafter. The trustee then asks for the first debtors on the calendar to come forward, and he asks those debtors which one of them, if they're a hubby-wifey, they'd like to have testify first. At the end of the examination, the trustee asks the unquestioned debtor in a joint case, "Did you hear the questions I asked your husband or your wife, as the case may be?" And then the trustee asks, "If I had asked you the same questions, would your answers have been substantially the same?" The first mechanical order of business is the inspection of the 2 forms of identification for both debtors in a married couple case. The trustees usually want to see a Social Security card and driver's license, and if the debtors do not have those or other ID acceptable to the trustee, the 341 meeting is usually continued to a later date, 30 or 60 days later, and the discharge of the debtor is often pushed back in time. And everybody is cranky at the debtor who didn't bring a Social Security card and driver's license. And sometimes the trustee gets really cranky. If he gets really cranky, that's bad. And your bankruptcy lawyer isn't going to be happy that he or she has to drive to court a second time on the case. And there's a good chance that your discharge will be delayed if you don't bring the Social Security card and driver's license to your first meeting of creditors. After the inspection of the identification, the trustee asks whether the address on the petition is still correct and tells the debtor to keep the court advised of any address changes until the case is closed. Note that there's a difference between the discharge order and the administrative closing of the case, which may be 2 years away in an estate with modest non-exempt assets for distribution to creditors. The trustee will ask the debtors whether they've read and understood the bankruptcy information sheet that contains basic bankruptcy information. If the answer is no, the 341 meeting will be continued until the answer is yes. I'll post a copy of the most recent version of the bankruptcy information sheet on my blog as soon as I scan one in. Technology is not particularly easy when you've been to your 40th high school reunion. The trustee will then ask the debtors whether they provided the information that their attorney used to prepare their petitions and schedules and statements, and whether the debtors reviewed the petitions and schedules and statements prior to the filing, and whether the debtors signed the petitions, and whether the petitions and schedules and lists and so on are true and correct and complete to the best of their knowledge and understanding at the time. The trustee will generally fish a little at that point on the issue of whether the debtor listed all of the assets. If you didn't list all the assets, especially big ones like cars and land and stock, you're dumb as a stump and you deserve what you'll get, which is bad. The trustee will then explore whether there are causes of action like whiplash lawsuits that were not listed which might be pursued as assets of the estate. The trustee then moves on to questions about inheritances and points out to the debtor that if the debtor becomes eligible to receive a bequest or inheritance within 6 months of the filing of the Chapter 7 bankruptcy, it's going to be property of the bankruptcy estate pursuant to 11 U.S.C. Section 541. Then the trustee explores whether there were transfers outside of ordinary support or Christmas-type presents over the course of the last year or so. The trustee is interested in whether the debtor may have given a preference payment to an insider or an ordinary creditor over the last year, or a fraudulent transfer to a creditor as well. A preference happened if the debtor gave his sister the Corvette in payment of a debt within the last year. A fraudulent transfer happened if the debtor gave the Corvette to his sister for Christmas or sold it to her for $1 within the last 4 years. The trustee will want to know how long the debtors lived in Arizona to establish venue and to establish appropriate exemptions. Venue is where the case should have been filed. The trustee will then explore the issue of who is eligible to file a Chapter 7 case and obtain a discharge by asking about any prior bankruptcy filings under this or different names and under this or different Social Security numbers. Apparently, somebody did actually file under an incorrect Social Security number at least once. The trustee then examines whether the debtor owes child support or alimony. Then the trustee asks whether the debtor has disclaimed, which is refused to accept, an inheritance within 4 years prior to the bankruptcy filing. Generally, debtors are not inclined to refuse an inheritance prior to filing because they need the money. The trustee then points out that he wants to see the upcoming tax return and that any tax refund coming to the debtor after the filing is property of the estate and must be turned over to the trustee on pain of losing the discharge. The trustees recently started asking whether the debtor has purchased a car within the last 2 months prior to filing, hoping that the bank or credit union has not perfected its position, and that the bankruptcy estate will get a free and clear car to sell. Of course, the debtor would also get $5,000 out of that. After the trustee is satisfied that the trustee's questions are answered and that the debtor has produced the documents the trustee has requested, and no, it's not really a request, the trustee will check to see if there are any creditors present to ask questions of the debtor. Creditors seldom send a representative to the first meeting because there's just too little time to get meaningful information out of the debtor. And that concludes a standard, unexciting first meeting of creditors. Sometimes they're way too exciting, but that's a topic for another day. Thank you very much.